This presentation provides a broad overview of the process by which the PSC sets rates for utilities within its jurisdiction. It applies to electric utilities, the largest natural gas distribution companies, to water utilities, and to sewer utilities. Some small utilities are eligible to use a simplified and streamlined version of this process. As with other matters under PSC jurisdiction, rate making is a legal process. It is governed by statutes enacted by the Kentucky General Assembly and by PSC regulations derived from those statutes. Also applicable are legal precedents set forth in PSC orders and in court decisions regarding the application of PSC statutes and regulations. The guiding principle in Kentucky statutes regarding rates is that they must be fair, just, and reasonable. Those terms are not defined in law, but their general meaning has been established over time through precedents and legal interpretation. In applying the statutes, the PSC seeks always to strike a balance between the interests of a utility and its customers. State law also states that shareholders in an investor-owned utility are entitled to an opportunity to earn a return on equity. Equity is generally understood to be the net value of the shareholder investment. In other words, the value of the utility's assets less the amount of debt attached to those assets. Note that the shareholders have only an opportunity, not a guarantee, of earning a return on equity. The appropriate level of return on equity is determined by comparison to similar utilities. The rate of return is at a level that will permit the utility to attract investment capital at competitive rates. Determining rates is a two-part process. It involves calculating a revenue requirement and then establishing a rate design. Let's look at those parts of the process in detail. But first, let's look at how the process works. Utilities must give the PSC at least 30 days notice before filing an application to adjust rates. They also must give public notice to their customers when the application is filed. The procedural clock starts running when the application is filed and determined by the PSC staff to meet all filing requirements. An application cannot be acted upon until it is deemed complete. The applied for rates cannot go into effect until 30 days after the application is filed. However, in practice, the PSC may, and usually does, suspend the rates for 5 or 6 months to allow for a thorough review. If the PSC does not issue a decision before the suspension period ends, the utility may put the rates into effect pending a final decision. But if the PSC ultimately grants rates lower than those requested, the utility must refund the overcollection to customers with interest. The PSC has 10 months from the time the application is filed to complete its consideration of the rate application. Once a final order is issued, any requests for reconsideration must be filed within 23 days of the order. Interveners are parties other than the utility that play a formal role in the proceedings before the PSC. By law, only the Kentucky Attorney General has the absolute right to intervene in cases before the PSC. Kentucky statutes designate the Attorney General as the representative of ratepayers as a whole. Other parties may petition the PSC to become interveners. In order to be granted full intervention, a party must show that it represents a unique interest not represented by the Attorney General, and that it will be able to bring forth evidence that might not otherwise come to the attention of the PSC. Parties granted full intervention are allowed to introduce testimony, ask written questions of the applicant and other parties, and participate in the cross-examination when the PSC holds its formal evidentiary hearing in a case. Examples of parties granted full intervention include groups representing interests such as large industrial customers, low-income residential customers, and environmental advocacy groups. The PSC infrequently has granted limited intervention. Limited interveners participate in the hearing, but do not present evidence, put on testimony, or engage in pre-hearing discovery. Parties may seek intervention once a utility gives notice that it will file a rate application. The application includes direct testimony by witnesses who will appear at any hearing held by the PSC. Just like direct testimony in a court proceeding, this pre-filed testimony is taken under oath, and any perjury is subject to penalties under the law. The same is true of any testimony filed by interveners. After the application is filed, there may be one or more rounds of written questions known as data requests between the parties. The PSC staff also files data requests. Responses to data requests are made under oath. The PSC is not required to conduct local meetings solely for the purpose of taking public comment, but may do so at its discretion. With or without public meetings, public comments are always welcome and will go into the case record for the Commission's consideration. They may be submitted by mail, fax, email, or through the PSC website. An evidentiary hearing is not required, but is customarily held in major rate cases. It is conducted much like a court proceeding. Although testimony is usually filed in writing in advance, witnesses appear under oath and are subject to cross-examination by counsel for other parties, by the PSC staff, and by the commissioners themselves. In complex cases, hearings may last several days. All PSC hearings are open to the public and are webcast on the PSC website. After a hearing is concluded, the PSC may ask for additional evidence or for briefs from the parties summarizing their positions. The PSC then takes the case under advisement. Decisions are rendered in writing in the form of a final order. A decision requires agreement by at least 2 commissioners. Parties to a rate case sometimes propose full or partial settlements in advance of the PSC hearing. When that occurs, the PSC will conduct a hearing on the proposed settlement and all other issues presented in a case. A full settlement must be unanimous. In other words, all parties to the case must agree on all the issues in the case. However, partial settlements are permitted. In such cases, all parties agree on one or more issues, or most parties agree on all issues, leaving the PSC to resolve remaining points of contention. Although a settlement typically leads to a streamlined hearing since the parties have agreed on most or all issues, it does not reduce the level of scrutiny the PSC applies to a case. The PSC will fully analyze the rates and other terms of the settlement and will fully review the settlement during the hearing. In order to accept a settlement, the PSC must determine whether the proposed rates meet the test of being fair, just, and reasonable. The PSC has the right to accept, reject, or modify all or parts of a proposed settlement. Now let's look at the 2 fundamental calculations used to determine rates. The revenue requirement is the total revenue a utility needs to maintain safe and reliable service and financial stability, and in the case of investor-owned companies, offer its shareholders the opportunity to earn a reasonable rate of return on equity. Revenue requirement is based on a 12-month period known as a test year. If it is a backward-looking or historic test year, the 12-month period must end no more than 3 months before the filing date of the application and uses actual financial information for the period. Forward-looking or forecasted test years are prospective 12-month periods that begin at the end of the suspension period. Because forecasted test years are more complex and require more review, the suspension period mentioned earlier is 6 rather than 5 months. To calculate a revenue requirement, the first step is to determine a utility's allowable expenses. These include routine construction, equipment and material purchases, operational costs including maintenance, billing, customer service, and others, personnel costs such as salaries and benefits, the cost of major construction projects once they go into service, and any borrowing costs. Certain expenses are not allowed. Advertising for promotional expenses is excluded by law. Executive bonuses, employee gifts, and similar expenses are not allowed. Charitable donations and club memberships also are excluded. The PSC has broad discretion to exclude any expense it deems to be unreasonable. Unusual or one-time costs or revenue are excluded from the test year so that they do not distort the revenue requirement. They are instead accounted for separately and spread out over time. Unusually high storm recovery costs may be excluded. Revenue from asset sales also may be excluded. The final revenue requirement includes all of the allowable expenses and a calculation that sets the rate of return at the appropriate level for investor-owned utilities, as well as for electric cooperatives, which calculate the level of revenue needed to meet the requirements set by their lenders, known as a tier. Certain utility expenses are not included in the revenue requirement and thus are not included in base rates. These include, for electric utilities, fuel costs above or below the amount included in base rates. These appear as a separate surcharge or credit on the bill. For gas utilities, the commodity cost of natural gas. It appears separately on the bill and is recovered on a dollar-for-dollar basis. Environmental compliance costs for coal-burning electric utilities. These appear on the bill as a surcharge. Energy efficiency programs for electric and gas utilities. These costs also are recovered as a surcharge as required by law. Surcharges to pay for assistance programs for low-income customers, and costs assessed by other entities, such as city or county franchise fees or local taxes. Once a revenue requirement is determined, the second step in the rate-making process is rate design. This process allocates both costs and revenues over various rate classes, including residential, commercial, and industrial categories. As part of a rate application, utilities submit cost of service studies that allocate costs over the various rate classes. In general, larger customers have lower costs of service due to economies of scale. Thus, the cost of service typically is highest for residential customers. Rate design also examines fixed versus variable costs. Fixed costs are those that do not vary with consumption, such as meter reading or customer service. Variable costs are those driven by usage. The PSC uses cost of service analysis as a guideline, but rates are not set strictly in accordance with the cost of service. Thus, large industrial customers, even if they pay lower rates than residential customers, typically pay rates higher than their cost of service would indicate. Conversely, residential rates do not fully recover the cost of serving those customers. The PSC typically does some rebalancing of rates in each rate class, both in terms of fixed and variable rates and allocation across customer classes. But those adjustments are done in small increments, in keeping with the PSC's long-standing policy of gradualism in moving toward fully balanced rates. Here are the various ways in which public comments may be submitted to the PSC. Include the case number in any comments, and that will ensure that comments are placed into the case file as quickly and as accurately as possible. Here is who to contact if you wish to obtain additional information.